The International Criminal Court is now in session.
Good morning, participants. Good to see you in court. I'm the presiding judge. My name is Daniel Nsereko. I'll ask my fellow judges to introduce themselves.
I'll be on the panel as well today. My name is Marie O'Leary.
Good morning. My name is Anna Richterová.
Thank you. Now, may I ask the participants to introduce themselves, starting with the prosecution side.
Good morning, Mr. President. My name is Lynn Sophie Temp, and I appear on behalf of the Office of the Prosecutor.
Thank you. And for the defense?
Good morning, Mr. President, Your Honors, and may it please the court. I am Fehmi Levent Özkan, and I'll be pleading for the defense today for 25 minutes.
Very good. Okay, thank you. I see that you are one-person teams. Okay, and you have the full time allocated to your teams, 25 minutes, I think. So, Office of the Prosecutor, you may start.
Thank you, Mr. President. May it please the court, the present matter is of considerable concern to both the Earthboer people and the international community. The alleged enslavement of at least 30,000 Earthboers cannot go without international scrutiny, and specifically, Lord Blaze must be tried for his conduct before this court so that his criminal responsibility can be judicially determined and his victims can obtain justice. Your Honours, I'll be making the following 4 submissions. Firstly, the court has jurisdiction in the case against Lord Blaze. Secondly, the case is admissible before this court. Thirdly, the prosecution would serve the interest of justice. And fourthly, there are reasonable grounds to believe that Lord Blaze is criminally responsible for the alleged crimes. Turning first of all to the issue of jurisdiction. Your Honours, the resolution of this issue turns on whether jurisdiction ratione materia can be established on the facts. The onus rests on the prosecution to prove this on the balance of probabilities in accordance with this court's decision and the 2010 decision in the Bemba case of paragraph 203. The prosecution submits that both the contextual and material elements of crimes against humanity of enslavement have been met. Therefore, our submission has 2 limbs. I turn now to the first limb, the contextual elements. We submit that the conduct has satisfied the contextual elements of crimes against humanity pursuant to Article 7.2 of the Rome Statute. We submit that the following 5 elements can be established. Firstly, there was an attack directed against the civilian population. Secondly, this attack occurred pursuant to a state policy. Thirdly, this attack was widespread or systematic. Fourthly, there was a nexus between the attack and the individual acts. And lastly, there was knowledge of the attack. On the first ground, we submit that the Earthboers civilian population were the primary target of the attack. Since the government crackdown in 2015, the Earthboer community has been prohibited from performing its rituals, speaking the Earthboer language in schools, and was subjected to other violations, such as frequently having the houses searched or being arrested without due process. Moreover, entire families were detained at Centre Reg, and in December 2018, BNS agents arrested and detained 40,000 Earthboer men and women simply for commemorating the 1,450 Earthboers killed during the summer 2018 protests. This suggests that the attack was in fact directed at civilians and not members of the armed forces or other legitimate combatants, as the defense will no doubt suggest. Secondly, Article 7.2 of the Rome Statute requires that the attack be committed pursuant to or in furtherance of a state or organizational policy. As the detention centers were set up by and overseen by the Ministry of Interior, following an executive order by Lord Blaze himself, this requirement is clearly satisfied. Thirdly, the pre-trial chamber in its Article 61 decision in the case of Bemba, paragraph 83, considered that a widespread attack entailed an attack carried out over a large geographical area, or an attack in a small geographical area, but directed against a large number of civilians. Nsereko alone housed about 30,000 prisoners, and there were 40 detention centers located throughout the Fire Republic. Accordingly, the attack was evidently widespread, both in terms of its geographical reach and the number of civilian victims. Indeed, in Bemba, for example, the court found that 1,000 victims was sufficient to meet this threshold. On the fourth element, we submit that the acts were not isolated. Indeed, the 2015 government crackdown was a campaign that against the Earthboer people that culminated in their enslavement. Finally, on knowledge, we submit that the perpetrators had the requisite knowledge pursuant to the case of Sonovich heard by the Peer Chamber in 2014. We note that Lord Blazer's specific knowledge will be addressed in my final submission in greater detail. But for the purposes of the contextual elements, the intermediary's knowledge is sufficient for the purposes of jurisdiction. For these reasons, Your Honour, we submit that the contextual elements are satisfied. I turn now to our second limb of the first submission, namely that the material elements of crimes against humanity of enslavement as set out in the elements of crimes, Article 7(1)(c).
Counsel, before you proceed, regarding the status of the ANG, is it not true that they were involved in some armed conflict with the members of the government? That therefore that qualifies them as combatants?
Yes, Mr. President, we do accept that there was an armed struggle between members of the AANG and the BNS. However, the prosecution submits that the primary target was nonetheless the civilian population. There might have been some combatants among those detained, but as I've previously set out, 30,000 people were detained at Nsereko alone. And we find it incredibly hard to believe that all 30,000 of these were terrorists, as the defense claims. As I've said, there were entire families detained, so women and children who would not have been combatants. And the actions from 2015 onwards show that it was in fact the civilian population that was targeted. For instance, priests were repeatedly arrested, and 40,000 people were arrested purely for commemorating their fallen community members. It therefore appears that, as we submit, the attack was primarily targeted at the civilian population, regardless of the presence of some combatants.
And the counsel, how do you define the attack?
Mr. President, the attack is defined as a number of acts of those listed in Article 7 of the Rome Statute. So it is the repeated enslavement of Earthboers, but also the other acts of aggression and persecution that the Earthboer community was subjected to.
Proceed, counsel.
Thank you, Mr. President. Turning then to the material elements of enslavement, the key issue here is whether there has been an exercise of ownership rights over the Earthboer people that were detained at Nsereko and the other detention centers. The crime of enslavement was considered by the International Criminal Tribunal for Yugoslavia in the Nuremberg case. The Peers Chamber stated that whether an act is a form of enslavement will depend on the indicia identified by the trial chamber in that case. I therefore point to the following 4 factors as evidence of enslavement. Firstly, the detainees were subjected to forced labor. The Earthboers' labor was effectively being loaned to Joe Snowflake's automobile company, which is supported by the available aerial footage and Haru Rock's testimony. It has furthermore been reported that detainees at Nsereko and the other camps were forced to work 12 hours a day, every day of the week. This is contrary to the UN's 2015 resolution on the standard minimum rules for the treatment of prisoners, specifically rule number 102, which states that prisoners should have at least one rest day. Secondly, there is evidence to suggest that detainees were subjected to cruel treatment and abuse. It has been reported that detainees that were too weak or refused to work were forced to stand outside in the snow all day in front of a picture of Lord Blaise without any food or water, under constant surveillance by BNS officers. Thirdly, severe measures were taken to prevent or deter escape. Harry Rock was the only survivor out of a group that tried to escape in January 2019, and aerial footage has also shown Nsereko to be a heavily guarded island fortress. Lastly, it has been reported that earthboers were prohibited from exercising their earthboers rituals and speaking their own language in these camps, and had their passports confiscated on arrival, which were not returned on their release. And this amounts to a form of psychological and physical control, we submit. For these reasons, it is submitted that the court has subject matter jurisdiction in the case against Lord Blaise.
And so the assertions you make, particularly about the conditions of detention, you base them on allegations by Harry Rock solely. Should this court accept allegations for Harry Rock?
He is an eyewitness who was detained there himself, and there has been corroborating evidence obtained from family members of those detained. There is also now potentially will be more evidence available if this matter progresses, as other detainees who fled the country have not been able to be interviewed yet. However, we submit that Harry Rock's testimony is credible, as it is consistent with the aerial footage that has been obtained.
Okay, proceed. And
thank you, Mr. President. Turning then to the issue of admissibility. In response to the defense's unfounded challenge to the admissibility of this matter, we submit that the defense has not dispensed with the burden of proving that this matter is inadmissible. The prosecution will make two submissions under this heading. Firstly, the amnesty procedure in this case is not a trial for the purposes of the Rome Statute. And secondly, the amnesty procedure did not deal with substantially the same conduct as this prosecution. Your Honour, the prosecution accepts that international law is still in the developmental stage on the question of acceptability of amnesties. However, the pre-trial chamber in the recent Gaddafi case noted a strong, growing, universal tendency that grave and systematic human rights violations are not subject to amnesties under international law. Irrespective of the court's consideration of the legal status of amnesties in the abstract, this amnesty is not sufficient to be invoked in any event. Pursuant to this court's decision last year in the case of Gaddafi at paragraph 48, Lord Blaise must have been the subject of a completed trial which resulted in a final conviction or acquittal, which has acquired res judicata effect. However, the amnesty procedure in the present case lacks any of the features consistent with the term trial, unlike some more comprehensive amnesties. In Lord Blaise's case, the amnesty is only confirmed that a public apology has been issued. Any judicial control was limited to confirming whether the preconditions set out in Article 3 of Law Number 14 on national reconciliation had been met. It therefore involved no interrogation of evidence speaking to Lord Blaise's role in the atrocities. It also appears that no voice was given to the opposing view. It is therefore not a trial in any meaningful sense of the word. Secondly, the amnesty does not cover the same conduct as this prosecution. Article 1 of Law Number 14 clarifies that it applies to those who took part in the hostilities in Black Mount. The scope therefore appears to be limited to the armed struggle between the BNS and AANG, rather than the enslavement of earthboers at Nsereko and the other detention centres. Secondly, as I have previously set out, any judicial control was limited to confirming that the preconditions for granting amnesties set out in Article 3 of Law Number 14 had been met. In short, the amnesty only confirms that Lord Blaise protests his innocence and has apologised for his lack of knowledge of the atrocities. In contrast, this prosecution would entail a thorough investigation of the facts and a fair assessment of whether Lord Blaise bears any criminal responsibility for the alleged crimes. The amnesty does not therefore cover the same or substantially the same conduct, and therefore cannot be invoked to stay this prosecution.
Also, can I stop you there? As I understand from the facts of the case, the amnesty was an apology to the victims for the atrocities committed by Ursa Azala. And also from the facts of the case, Ursa Azala is the one who had put into place the labor camps. Is the prosecution charging anything beyond the labor camps here? Because otherwise it would seem that it is directly the same conduct, the labor camps themselves, that are a part of the amnesty for which he apologized for. Thank
you for that question. The answer to that is the amnesty the apology was directed for the actions of Ursa Azala. However, she, as the Minister of Interior, was the one in command of the BNS. And the BNS, as I've previously stated, was engaged in an armed struggle with leaders of the ANG and committed atrocities outside of the camps as well. We therefore submit that there is an ambiguity, but we submit that the amnesty did only apply to the hostilities as opposed to the slave labor camps, even though Ursa Azala was also in command of these as well, obviously. Thank you. Turning then to the interests of justice, we have two submissions to make under this point. As a preliminary matter, the prosecution submits that whether this prosecution would serve the interest of justice is not a matter for this pre-trial chamber to review. And alternatively, the case would serve the interest of justice in any event, given the gravity of the offence and the interest of victims. Following last year's decision in the situation in the Islamic Republic of Afghanistan appeal, the appeals chamber held that a pre-trial chamber is not called under Article 15(4) of the statute to make a positive determination of the interest of justice. While the present case, of course, is not one in which the office of the prosecutor initiated the investigation proprio motu under Article 15, the prosecution submits that the same principles ought to apply to cases in which a situation has been referred to the prosecutor by a state party. In any event, Article 53, paragraph 3b, suggests that this is only for a pre-trial chamber to review a decision by the prosecutor not to proceed, which is not the case here for obvious reasons. Should your honours not be persuaded on this point, the prosecution furthermore submits that the case would serve the interest of justice given the gravity of the offence and the interest of victims. Your honours, the appeal decision in the Afghanistan case explained that a prosecutor, again, is only required to consider whether a prosecution would not be in the interest of justice. We submit that there are no convincing or credible reasons why this prosecution would not be in the interest of justice. While Lord Blaise argues that it would not be in the interest of justice to continue as it would destabilise the peace process, his assertions without more should not be determinative on this issue, given that Lord Blaise obviously has a direct vested interest in arguing so. In any event, the situation in Blackmount has been stable since the peace agreement was concluded in the summer of 2019. There's therefore no evidence to support Lord Blaise's contention. On the contrary, we submit that this crime is a serious crime which weighs heavily in favour of pursuing this matter. As stated in the 2004 decision in the Morris-Callan case of paragraph 31, the gravity of the crime will be assessed quantitatively and qualitatively, taking into account its scale and nature and the manner and impact of its commission. As I've previously mentioned, these are very grave alleged crimes. 30,000 earth boers were imprisoned by the BNS at Nsereko alone, and Nsereko is described as one of the biggest detention centres, suggesting there were likely even more populated sites. Entire families were being held and people were arrested only on the basis of commemorating the death of countrymen, suggesting an indiscriminate approach as to whether actual combatants were detained. And I've previously touched on the dire conditions that detainees were subjected to at these camps and the forced labour that they had to endure during the length of their detention. For these reasons, we submit that the gravity threshold is met and it would be in the interest of justice to proceed. Turning then to my final submission, regarding Lord Blaze's criminal responsibility under Article 28B of the statute. The crux of this issue turns on whether there are reasonable grounds to believe that Lord Blaze had the requisite knowledge, control, and ability to take all necessary and reasonable steps to prevent or stop these crimes of enslavement. We submit that Lord Blaze did have criminal responsibility for crimes against humanity of enslavement for the following 3 reasons. Firstly, Lord Blaze had a superior relationship, subordinate relationship between Azila and the BNS. Secondly, he had the requisite mens rea. And finally, he failed to take any steps to prevent or stop the commission of these crimes. Firstly, following the Bemba case, the interpretation of the term subordinate is broad and covers both de facto and de jure control of subordinates with regards to the ability to prevent or punish the commission of this crime. As president, Lord Blaze clearly had the power to issue orders. The exhibits and case facts show that Lord Blaze had the power to issue orders to Azila regarding the organization of the camps and to order the release of prisoners, as well as the power to stop the commission of any of these crimes, given that he ordered the BNS to bring an end to the conflict and dissolve the camps. Lord Blaze therefore clearly had a superior relationship with relevant agents. Secondly, he had actual or ought to have knowledge of the crimes. It is not in dispute, reading exhibits 1 and 2 together, it is clear that Lord Blaze was aware of the very dire conditions in the camps, and that the detainees were not so much learning trade skills, but being made to work on an industrial scale. Given that Haru Rock gave his account of the prison conditions in an interview to an international NGO, we find it hard to believe that Lord Blaze was not made aware of this as well. Given the national security threat that the Black Man represented, we invite the court to find that Lord Blaze acted with willful ignorance by decreeing that he would only receive updates from the BNS once every 6 months. At the very least, Lord Blaze consciously disregarded information which clearly indicated that his subordinates were committing crimes against humanity of enslavement. At most, he knew of the nature and scale of what was happening.
But he received the reports only once in 6 months. How did you expect him to get information other than that? How do you know he knew? What evidence do we have that he knew more than what was contained in these 6 month reports?
Certainly, Mr. President, there's obviously Exhibit 1, the telephone conversation between Oza Azila and himself, as well as the order, which is Exhibit 2, where his office is authorizing sending further manufacturing supplies to the camps. And as I've said, the fact that information of these dire conditions at the camps was brought to the attention of international NGOs, we find it hard to believe that Lord Blaze was not aware of what was going on in his own country.
Okay, and according to Exhibit 1, I think line 6, when he learned that the number of people that were at the labor camp, he showed, concern and said this was too much. Isn't that evidence of innocence? Showed sympathy, said this is not too much, and this tends to negate mens rea?
Mr. President, we submit that the reason he said that was too many is because he was worried about opening himself up to a mutiny. This is entirely self-interested rather than a sign of his innocence. He was clearly aware of how dire the conditions were, and that's why he feared a mutiny. And that's the reason why he held back on, or suggested not sending further prisoners there.
Thank you.
I'm sorry, just to interrupt. Can you tell us, is there any ICC authority regarding the superior? Because you state that Lord Blaze was responsible as a superior. Is there any case law on this?
Yes, so I've quoted the Bemba Gombo case, which states that circumstantial evidence can be used to demonstrate his knowledge of the crimes. So that case considered the existence of an effective reporting system being in place as demonstrating a priori knowledge. So that's Bemba Gombo paragraph 431.
But it's a military commander. This is a civilian. Is there any case law concerning a civilian?
Well, again, I'm sorry, I'm not currently aware of a ICC case. There is the ICTY case of Karajek and Musjek, where this point is explained that as president, he had de jure authority, and that there's this presumption of authority, which we say is also available, is also de facto control. And those two decisions were cited with approval in Bemba Gombo. And although, as you note, obviously the factual situation was slightly different in Bemba Gombo than it is here.
Thank you.
Thank you. Returning then to my submissions, as the detention centres were administered by the BNS and the president provided raw materials to the centres, it should follow that these crimes were clearly within the control of Lord Blaise, and he failed to take any necessary reasonable measures to put a stop to the crimes, even where he was in a position to know, or at the very least have reason to investigate what was going on. Only when the violence risked spreading beyond the Black Man's borders did Lord Blaise put an end to the conflict. Yet he did not submit the matters for investigation by the competent authorities. There are therefore reasonable grounds to believe that Lord Blaise is criminally responsible under Article 28B of the statute. Unless I may be of any further assistance to the court, that concludes my submissions. Mr. President, you are muted.
I was thanking you for your submissions.
Thank you, Mr. President.
And expressing our indebtedness to your presentation. And, I think this will be helpful to us in reaching a decision on the matter. Now, defense.
Thank you, Your Honor. Mr. President, Your Honors, good morning again, and may it please the court. In response to the prosecution, the defense will make 4 submissions. I will demonstrate, firstly, that this case does not fall under the subject matter jurisdiction of this court. Secondly, that this case is inadmissible before this court. Thirdly, that this case does not serve the interests of justice. And fourthly, that Lord Blaise is not individually criminally responsible under Article 28B. Turning to the first submission, that this court does not have material jurisdiction over this case. The prosecution argued that the crime against humanity of enslavement has taken place within Nsereko, and in doing so, they quoted the Kunarach judgment, and they stated that individuals were forced to work within Nsereko for a car company. Now, within this submission, I will first submit what the requirements of enslavement are, and then I will move on to show that forced labor has not been met in our case. Firstly, according to the elements of crimes on the requirements of enslavement on Article 7.1c, the requirement is indeed the exercise of ownership over individuals, just as the prosecution has suggested. However, this acts of exercise of ownership can be bartering, selling, purchasing, and in some circumstances, according to the elements of crimes, forced labor. Now, in Kunarach, paragraph 542 trial chamber decision, it has been stated that detention in and of itself cannot amount to enslavement. There needs to be a more severe act, such as the ones given in the elements of crimes of the Rome Statute, and such could be forced labor. However, in our case, forced labor cannot be met. Turning to the requirements of forced labor, according to Article 2 of Forced Labor Convention of 1930, it is clear that forced labor requires either a lack of consent or a consent rendered irrelevant by a menace of penalty. In our case, the earth bowers had consent, and their consent was not rendered irrelevant by a menace of penalty. If I may turn your attention to paragraph 9 of the case fact, and paragraph 8 as well. Your Honors, in our case, there has been an opening of 40 centers within the Fire Republic. Within these centers, an education program on mechanics and trades was set up. This is also corroborated by Exhibit 2 to the case facts, which shows the sending of an engine, steel, rubber, and glass to the center. These are used for the education purposes. Moreover, if individuals wish not to participate within this program, they were simply held as normal detainees and served the rest of the sentence with the others. There was no compulsion, no menace of penalty. The individuals could give consent. And regarding the fact that the consent was not rendered irrelevant, Your Honor.
Counsel, may I stop you there? If you go to paragraph 12 of the fact, and you say that if they didn't consent, there were no consequences. They were taken as regular detainees. That's your contention, but we read that if they were the last sentence, if detainees were too weak or refused to work, what were the consequences? They were forced to stand outside in the snow all day in front of a picture of Lord Blaze without food and water, with BNS officers watched. Did they have did they have an option? Were they free in this matter?
Your Honor, if I may turn your attention to that paragraph, indeed, there is an allegation by one individual out of 100,000 supposed detainees that claims that there was a manner of coercion. Your Honor, coercion or forced labor cannot be established on the basis of only one individual who was allegedly detained. We see this in the Kurnayalaj Appeals Chamber Judgment, paragraph 195. What we have here is the prosecutor attempting to prove forced labor and enslavement on the basis of one individual's words that was not corroborated in regards to the forced labor or the menace of penalty to show that there is enslavement. Your Honors, this does not meet the requirement of reasonable grounds to believe, let alone the balance of probabilities that was suggested by the prosecution. There is no reasonable grounds to believe, or in the balance of probabilities, it is not likely, it is not fair and sensible to put Lord Blaze or put any individual in front of a criminal prosecution on the basis of the uncorroborated statements of one individual. Therefore, this court does not have jurisdiction, since it cannot be established to the required degree of proof in our case, in our situation. The crime against humanity of enslavement cannot be proven, and the court does not have jurisdiction.
So can I stop and ask a follow-up there? You've cited to the ad hoc jurisprudence about corroboration. Does the Rome Statute and its instruments require corroboration, especially at this stage of the case where we're not even at the trial stage?
Your Honor, there is no legal requirement of corroboration, not in the ICTY or not in the Rome Statute. Indeed, Rule 63 of the Rome Statute states that there is no legal requirement for corroboration. However, we submit that although there is no legal requirement of corroboration, at the current stage and with the current evidence at hand, it is not reasonable to believe that Lord Blaze has that the crime against humanity of enslavement has taken place, although a legal requirement of corroboration is not there. Moving on to the second issue, which is...
I'm sorry to interrupt. I would also like just to follow one question. You know, we are talking about at least 40,000 of detainees. What was the legal base for the detention? Because you were talking about their consent. Was there voluntarily, or was there any trial that would make them to work? Were they punished with something?
Your Honor, in regards to consent, it is different for a consent to be detained or a consent to be forced to work. In our case, the basis of detention is the anti-extremism executive order on paragraph 7. However, this by itself, or the detention by itself, according to Kunoraj paragraph 542, does not amount to enslavement. Here, our issue is not the deprivation of liberty of individuals, such as their detention, but the deprivation of liberty of the individuals, which on a sense that arrives to the threshold of exercising right of ownership. Therefore, we submit that individuals were not enslaved in our case.
But they were not tried. They were detained based on a presidential order.
No, Your Honor, we do not have any case files that suggest that they were tried to be put into centers. However, it is a different issue than the enslavement. Moving on to the issue of admissibility, Your Honor, the prosecution submitted that the case is inadmissible because this is the amnesty does not constitute a trial in the meaning of Article 17, and that the amnesty nonetheless is not of the same conduct that is being seen as being the subject of the complaint in this proceeding. Regarding the meaning of tried under Article 17, which I will address first, the prosecution quoted the Gaddafi judgment. Now, in this stage in the Gaddafi proceedings, Mr. Gaddafi was convicted by the court of Tripoli. However, this conviction was not final. He required that the conviction in Tripoli to be final, to have the matter finally settled. Your Honors, that is the crux of that decision, and that is why within the pretrial chamber judgment of Gaddafi, the word final is emphasized and a res judicata effect is looked for. We require the matter to be finally settled. This also follows from the logic of Article 17(1)(c), which is under the complementarity principle of the Rome Statute. Your Honors, according to the preparatory works of the Rome Statute, paragraph 160, it is clear that the drafters of the Rome Statute considered amnesties to be part of the complementarity regime as well. Furthermore, a blanket ban on amnesties or any ban of amnesties was rejected by the Preparatory Commission. Therefore, it is clear that a final judgment on the conviction or acquittal is not required, but a final judgment which settles it is. And according to the clarifications of the case fact, clarification 5, this matter has been settled.
Wasn't this the pardoning of Lord Blaise, wasn't it part of a blanket pardon? Since there was no trial, no investigation, no trial, no conviction of any offense?
Mr. President, this is not a blanket amnesty, because if, according to law number 14, if individuals would not be subject to amnesty, or if this amnesty, the conditions of the amnesty were not met, they would be prosecuted. And we have a conditional amnesty where Lord Blaise has to confess and has to declare his activities, and then he will be given an amnesty. And there is a judicial review on the end of the matter, which has confirmed that the amnesty applies to Lord Blaise. And this takes me to the second point of the prosecution. The prosecution stated that the amnesty did not cover the same conduct of these proceedings, perhaps namely the actions within the center rig. However, we see, Your Honors, that a fiery public judge has already confirmed that Lord Blaze does have, is to be given the amnesty for the hostilities that taken place between those dates, which includes the actions within center rig. Now, firstly, individuals were taken to center rig as an extension of the conflict or the unrest. And furthermore, Lord Blaze's apology indeed also had the center rig or the detention centers covered within it. And the judge of the Fire Republic has confirmed this, and the ICC is not a fourth instant court. So the ICC cannot state that the Fire Republic judge erred in its decision. Therefore, this case is not inadmissible since it falls under 17(1)(c) and it covers the same conduct. Moving on to
what conduct?
Your Honor, the conduct of the case here before the ICC is the alleged crime against humanity of enslavement within center rig. Here, according to the case facts, the amnesty covers hostilities between anyone who took part in the hostilities in Blackmount, according to paragraph 19. And in our case, Lord Blaze is the head of the Fire Republic government, and therefore he is under the amnesty. And conduct within center rig was also a part of the alleged hostilities between the parties. And as we see on paragraph 21 of the case fact, when the peace agreement was signed, the detention centers were closed. And therefore, it is clear that the center rig, the acts within center rig falls within the scope of amnesty. Moving on to the issue of interest of justice. Your Honors, firstly, I will argue that this, briefly, however, that this chamber has the power to review the interest of justice, and secondly, that this case does not serve the interest of justice. Regarding the power to review, the prosecution quoted the Afghanistan decision to state that the chamber does not have power to review. However, Afghanistan was a fundamentally different situation where the prosecution was the only party and the prosecution attempted to initiate an investigation. In our case, we have a prosecution which is fundamentally different than the Afghanistan decision, and therefore Afghanistan decision shall not be applied. In our case, we have a challenge by the defense, and therefore it shall be also the court shall also review the decision of the prosecutor, and we submit that it is the pretrial chamber's duty to exercise powers of judicial review over decisions of the prosecutor, as stated by this court in paragraph 93 of Comoros judicial review decision. Since this chamber is the supervisory body over the prosecutor, it has the power to review the prosecutor's judicial considerations, and in the interest of justice falls under such category. Now, turning to the substance of the interest of justice, this case does not fall under interest of justice because it jeopardizes the peace within the Fire Republic. Within this claim, I will first outline why peace processes fall under interest of justice, and second, why this peace is jeopardized. Your Honors, according to the OTP policy paper on the interest of justice, page 8, crime prevention and security falls under the interest of justice considerations, and this statement is made under the heading of peace processes. Furthermore, it is the international community's interest, the overarching theme of international community, to establish lasting peace. And finally, according to the United Nations General Assembly resolutions, peoples have a right to peace. Therefore, it is clear that peace falls within the interest of justice considerations. And in our case, peace has been jeopardized by this prosecution. Your Honors, the Fire Republic faced 4 years of unrest before finally the government of the Fire Republic called for peace, and together with the other party, the AANG, they signed a peace agreement on paragraph 17 of the case facts, finally bringing peace to the region. However, following this, the Earth Nation, a nation not party to the conflict, referred the case to the prosecutor. Now, what the prosecution does is undermining the essence of the peace process, because the peace process had been built upon an amnesty and a Truth and Reconciliation Commission. This Truth and Reconciliation Commission has already delivered a report according to the clarifications of the case facts. Now, the prosecution of Lord Blaze completely undermines the foundation of this peace by undermining the Truth and Reconciliation Commission and the amnesty, and it antagonizes Lord Blaze's government, which was the government, or Lord Blaze himself, that first called for peace under, as we see on paragraph 17 to the case fact. And therefore, this case is not in the interest of justice. Moving on to the individual criminal responsibility of Lord Blaze.
Can I stop you on the interest of justice? Whether it is or is not in the interest of justice to prosecute this case, you've cited to the OTP's policy paper here. Is it for this chamber, for this bench, to consider the interest of justice, or is that a consideration that the prosecutors already made?
Your Honor, this chamber shall entertain its right to judicial review, as this chamber is the supervisory body of the prosecutor. The considerations and decisions of the prosecutor are up for judicial review, as we see on Comoros judicial review decision, paragraph 93. And since this is a consideration and decision of the prosecutor, this chamber shall exercise its power to review and make its own review.
As in our decision, the Comoro case been overruled by the appeals chamber?
Your Honor, not on that sense, no. Moving on to
that.
Your Honor, the judicial review decision that the part we cite sets out the reason of the existence of the pre-trial chamber, and therefore the fact that it was accepted or the judgment was overruled on different matters does not change our position that this chamber is indeed formed to exercise judicial review of the prosecutor. Moving on to the individual criminal responsibility, we submit that Lord Blaze cannot be held individually criminal responsible because he does not have the requisite knowledge of the enslavement, and that he did not have effective control over the BNS agents in Center Rig. I will first address the knowledge requirement. The prosecution stated that Lord Blaze knew of the crime against humanity of enslavement going on within Center Rig, firstly by citing the international NGO report, which was published. And they stated that since this report was out, he should have known. However, we see on clarifications of the case facts, number 4, that this report was published after the conflict in February 2020. Therefore, this report could not have alerted Lord Blaze to any crimes happening, as it was not out yet. And the prosecution cited that there were very dire situations within Center Rig, and he knew about this, and therefore he should know about the enslavement. However, the dire situation or the conditions of detention itself cannot amount to enslavement, because there is no knowledge in Lord Blaze's mental element that there was a menace of penalty. If we turn to Exhibit 1 of the case facts, which was also cited by the prosecution to prove knowledge of Lord Blaze, we see that Ursa Ezila states that the detainees are working on something and that she requests materials for Center Rig. In response to Center Rig, materials of, as I've stated before, materials to be used in the education center have been sent. This shows that Lord Blaze knows that an education center is being manifested within these centers, and not an enslavement or not a forced labor is going on. Secondly, the prosecution relied on the reports to show that Lord Blaise had knowledge and that there was an established reporting structure. However, when we see on paragraph 7 that these reports were sent in every 6 months, and according to clarification 2 of the case facts, these reports were sent in accordance to this order. So this means that Lord Blaise received only 1 report before the end of the conflict. And to be fair, Your Honors, we have no indication or no knowledge of what these reports entailed of and what they indicated. Therefore, we cannot clearly suggest that Lord Blaise consciously disregarded information that suggested that crime against humanity of enslavement was taking place, as we have no information regarding these reports. Moving on to the effective control, Your Honors, if I may turn your attention to paragraph 12 of the case fact, it is the BNS agents who have been alleged of conducting the crime against humanity of enslavement. We submit that Lord Blaise did not have effective control over them. The definition of effective control is the material ability to prevent or punish crimes. Indeed, in Bemba Trial Chamber Judgment, paragraph 188. This is not contested. What is contested is when a person has the material ability to prevent or punish or repress. Your Honors, according to the opinion of Judges Morrison and Van den Weingart on the Bemba Appeals Chamber judgment, which did not have a consensus on when this material ability is reached, it was stated that the material ability is reached if the individual has the power to effectively monitor the situation, and that if they are an immediate subordinate or immediate superior. In our case, Lord Blaise is the president of the Fire Republic, and therefore he cannot be the immediate superior of these individuals, and he cannot effectively monitor or effectively prevent these individuals from committing any crimes if they even have happened, as there are also no reasonable grounds to believe that these crimes have in fact happened, as the only evidence the prosecution relies on is the statements of one individual. Since Lord Blaise does not have effective control over the perpetrators, and there's no clear indications that he knew of the crime, he cannot be held individually criminally responsible. Thank you for your time.
Thank you, Mr. Defense Counsel. Now it's time for Roberto, and Madam Prosecutor, you have 5 minutes of Roberto.
Thank you, Mr. President. I have 3 short submissions to make as rebuttal. First of all, with regards to my learned friend's arguments on the issue of forced labor, he rightfully pointed out that forced labor is evidenced by a lack of consent or consent rendered irrelevant by menace of penalty. And as the bench quite rightfully pointed out, there clearly was this element of punishment here, that being forced to stand outside in the snow all day without food and water. And there's an analogy to be drawn to the case of Canayola, which is another ICTY case in which the punishment was solitary confinement. And in that case, it was considered that this was sufficient to show that the labor was forced and consent was negated. The defense suggests that there was no punishment, and yet this is only based on the press interview given by Urza Azile. Yet the defense takes issue with the fact that the prosecution's evidence is based currently solely on the evidence of Haru Rock. He therefore asks us to take her word for it over that of someone who actually was in the camps and experienced the dire conditions there. Özür Özel clearly has a motivation for presenting the situation in a more positive light than was actually the case. Therefore, we submit Özür Özel's assertions should not be taken at her word without more. And quite rightly, we are still at a very early stage, and the prosecution merely needs to show that there are reasonable grounds for this case to proceed. We're not trying to prove conclusively whether Lord Blaze, whether these crimes occurred. However, there's strong corroborative evidence to suggest that these crimes were committed. And as was also quite rightly pointed out, there was no legal basis for the detention of many of those detained at Nsereko and the other camps. Large number of ANG loyalists were detained without due process or facing any trial, and detainees were neither informed of the reason for the detention nor its length. And for that reason, we submit that this is clearly a case of forced labor on the available evidence, of which there will be more if this case was to progress. On the issue of the interest of justice, Article 53, subparagraph 3, suggests that provides the option for pre-trial chamber to review a decision by the Office of the Prosecutor not to prosecute. No such provision is made for a decision to prosecute. The plain reading of the statute therefore dictates that the prosecutor's determination of the interest of justice is not reviewable by the pre-trial chamber once made. And this is also consistent with the objectives of the Rome Statute, which is the prevention of serious crimes of concern to the international community through ending impunity. In any event, Article 16 of the Rome Statute provides that the United Nations Security Council may pass a resolution to defer an investigation or prosecution on the basis of maintaining international peace and security. This is the only provision that explicitly permits concerns about peace to override the decision to investigate and or prosecute. It's therefore for the UNSC and not the Office of the Prosecutor or this pre-trial chamber to replicate. And the interest of justice test therefore cannot be wide enough to give consideration to these factors of peace and stability, as Lord Blaze asked of this court. That would be to usurp the role of the UNSC. And the only considerations which are to be taken into account in Article 3 are, which are listed there, are the gravity of the crime, the interest of victims, or the age and infirmity of the alleged perpetrator, as well as his or her alleged crime. Again, there's no mention of issues relating to peace and security. And turning very briefly to...
Council, this matter was not referred to the court by the Security Council, but by one of the state parties, unless I'm wrong.
Yes, Your Honor, and I'm not trying to conflate these issues here. It was definitely submitted by a state party. I'm merely trying to make the point that interests of peace and security are not one's factors which should weigh heavily in the interest of justice test for the Office of the Prosecutor, even if it is reviewable, that being, again, a different matter.
Proceed, Counsel.
Thank you, Mr. President. Very briefly on the issue of knowledge, the line 14 of Exhibit 1, Azila states that we might need more men and supply. That clearly suggests that she's asking for more detainees to be sent to the camps. This is clearly inconsistent with the defense's assertion that these were purely educational camps where detainees were learning trades. This is an industrial scale production operation where she's asking the president to send more detainees there to work. And for that reason, we submit that Lawblaze must clearly had the requisite knowledge of these camps being more than just education centers where detainees were being taught trades. That concludes my rebuttals. Thank you.
Thank you. Defense?
Thank you very much, Mr. President. Good afternoon, Your Honors, and may it please the court. In response to the prosecution, the defense has 3 submissions. I will first address the prosecution submissions about Exhibit 1 on knowledge. The prosecution submitted that since more men and supplies are requested, this means more detainees. However, in the same exhibit, we see that Lawblaze is diverting detainees out of the detention center to make sure that their conditions are improved. This means that the more men and supplies does not mean more detainees. It means more guards and more supplies for the education center, as we see on Exhibit 2, which authorized the sending of such materials. Moreover, Your Honors, we see that within this supposedly industrial scale of 40 detention centers, out of these 40, only 1 individual came up, although every detainee so far has been released according to paragraph 21 and paragraph 22 of the case facts. This does not show that this was an industrial act. This shows that that there is no enslavement or no means of penalty whatsoever. Now, on that, I will move on to the second point, which was the first point made by the prosecution on forced labor. They stated that we relied on we relied on Ursa Ezila while they relied on Haru Rock. This means that the prosecution alleged the defense of making a he said, she said case, for want of a better phrase. Your Honors, we see on Article 66 of the Rome Statute that the burden of proof is on the prosecution, and there is no other evidence, although so many detainees were released, that these events have even, this menace of penalty has even taken place. Your Honors, the burden of proof, the standard of proof has not been met at all. May be reasonable grounds to believe, or may it be the balance of probabilities. Reasonable grounds means within reason, and according to Kenya, paragraph 30 of the Article 15 decision, reasonable means fair and sensible, and it is not fair and sensible to bring an individual in front of an international court with such lack of evidence. Furthermore, the prosecution argued that the detention had no legal basis and stated that this shows enslavement. However, the no legal basis is for the detention, and as we have submitted in our main pleadings, according to Kunaraj, paragraph 542 of the trial chamber, detention by itself cannot amount to enslavement. Your Honors, we are not here to discuss the detention of these individuals or whether they committed another crime or they were victims of another crime. We are here to discuss, according to paragraph 28, whether the crime against humanity of enslavement has been committed. And there is simply not enough evidence to show that individuals were subjected to a menace of penalty. Moving on to the second point of the prosecution and our final point, the prosecution argued that the Article 53(3)(b) prohibits the pretrial chamber to exercise its jurisdiction, exercise its power to review on the positive determinations of prosecution. Now, Your Honors, that article, the reason the article is there is indeed to ensure prosecution, and this gives the chamber the explicit power to review the consideration if there is a decision not to prosecute. However, it is silent as to what happens if there is a decision to prosecute. And we submit, since this chamber is the supervisory body over the prosecution, and since there's a challenge by the defense in this case, this power to review must be exercised over interest of justice. Your Honors, this is an issue of defense rights as well, and the equality of arms. The prosecution cannot be allowed to have a monopoly in such a consideration where individuals cannot be prosecuted if the case is not in favor of the interest of justice. Thank you very much.
Thank you, Counsel. Unless my colleagues have any question, we thank you both. We'll retire and deliberate over this matter, and we'll come back to and let you verdict.
So I will now send the judges to the deliberation room and the teams to separate breakout rooms.
Okay, are we ready to go? Thank you. I don't see the participants. Where are they? I don't see the team members. Nevertheless, you probably.
The team members are here, so you can start.
Thank you. Thank you, team members, representative of the Office of the Prosecutor and representative of the defense. We are being delighted to listen to your presentations and thank you for assisting the bench in unraveling this difficult case. And we are not called upon to give a verdict whether on the merits of the case, but on your performance. Before we give our view, or rather determination, we would like to make some general feedbacks, general comments. I'll ask my colleagues to make their comments. Anna?
Thank you. I will start, and I can only repeat that it was a real pleasure to listen to your arguments. You prove a very good knowledge of international law, but there is always a room for some improvement. When you argue, it's really nice if you can offer more case law that would support your arguments, not just one decision, but you can cite more international authorities. Also, when case like this, you cannot be strong on all your points. Take one really strong point and focus and develop this point to convince the judges. That's all from my side. I would like to ask my other colleague to give her opinion.
Thank you, Judge Richterová, and thank you, Presiding Judge Nsereko. I just can only, come and jump in on this again and also say it's always a privilege at this point in the stage of the moot court to be able to judge, because it has come a long way and you are very fine, these arguments, and everyone did incredibly well today. It was no exception. But don't lose steam, hang in there going forward. You have to hang out to the very end. On the citation point, I just want to say, actually, yeah, thinking about it after the round 2 today, if you can, to any degree that you can pinpoint a little bit better when you do use cites, you did sometimes, not always, but you say Bemba, is it the confirmation of charges? Is it the appeal judgment? Is it the trial judgment? Just throwing those 2 words in there help guide my attention, or any of the judge's attention, to exactly which decision, what bench it was that was making the decision. That's really helpful, especially the longevity of some of those cases at the ICC. Watch the sticky points, know those case laws, the case law that you're citing inside and out, and anything associated with it. But the most important going forward, I think, is, and always believe in your own case so that it comes through really well, and believe in yourself. and have that confidence, and that'll get you miles further ahead always. So thank you so much to all of you. It was a pleasure for me as well.
You are muted.
Okay, I was thanking my colleagues for their comments, and I want to associate myself with the views they have expressed, believe in your case, and present it forcefully and enthusiastically if you can. And you've been at it for quite a long, and we are towards the end of the process. And I agree with my colleague, must not lose steam because it's very important in these proceedings that when you come towards the end, you should be at your best. Again, we cannot overemphasize the importance of the jurisprudence that we rely on in making decisions. And thoroughly well at your fingertips. And if your colleague on the other side decides a case, be ready and willing to distinguish it if you can. If you can't, just accept and then acknowledge it and then move on. And we were generally happy at the level of your knowledge of international criminal law. For us who are practicing it, we are delighted that you are in it, that that you've prepared thoroughly, and you studied the Rome Statute and rules of procedure and evidence, and hopefully more jurisprudence, and of course also the jurisprudence of the ad hoc tribunals, because as you know, the ICC relies heavily on the jurisprudence of those tribunals that have gone before it, who have been trail blazers. And I commend you for your performance, and I hope that you not stop only at moot courts, that one day you will participate in a real court, whether here in The Hague at the ICC or in ad hoc tribunals which are still in existence in one or the other role. Generally, it has not been easy to say which team is better than the other, because your level of performance has been very good, almost at par. But we've been required to say which one has been the best team. And we've come to the conclusion that the defense has had an edge, and that has been the best team. With those words, I thank you and wish you well in your endeavors currently and in the future, particularly if you choose to pursue a career in international law or international criminal law or humanitarian law, whatever you choose. Best of luck, and we need more of you in this field. Thank you, and I thank the organizers of this moot competition for enabling us to participate and play a part. Thanks.
Thank you very much.
Thank you very much indeed.
Thank you very much. I will now first